Hello students, I am Nigatu is Business Law. This video tutorial was prepared to assist you better understand the main material posted on the university Telegram channel. Please be alert, stay at home and safe. Remember that you are an invaluable asset for your country. Chapter 1. General Introduction. Outlines of the chapter objectives. After completing this chapter, the students are expected to understand the following main chapter objectives. There are 4 general chapter objectives you are expected to understand: the definitions of the law, basic features of the law, purpose and function of the law, and meaning of the business law. Let's consider these as following. Okay, definitions of law. You may encounter that many scholars may define law in different ways, because the law is going to serve different purpose, and based on such a purpose that it's going to achieve, it can be defined in different ways. But generally, there is one agreed definition of the law. That is, law is a rule of conduct, or law is an action prescribed or formally recognized as binding or enforced by controlling authority or government. So from this definition, you can consider that law is generally a rule that governs conduct or an action. But students, you have to consider that not all rules are laws. So for a rule to be law, it has to fulfill the following basic characters. The first one is it must be prescribed by government. Prescribed means that is enacted by government. Law should be enacted by government. As you may know, there are different laws that are enacted by government. For example, the House of People Representatives proclaimed proclamation, Council of Ministers issued regulations, and different ministers going to issue directives. These are what we call prescription of the law. And governments should also recognize laws that are not prescribed by government. When we are saying recognition, governments must give some recognition for rules to be law. Best example for this is law of contracts. The law of contracts stipulated different provisions for individual negotiators. So any contract that's entered between institutions and individuals, and even maybe between individuals, recognized by government, and it should be treated just as a law. The second feature that a rule must fulfill in order to be law is it must be binding one. All citizens as well as government officers must be bounded by the rule. So law is not partial, it must be impartial. It must bind, it must force other people, the citizens, the subjects, and also the parties of the contract to fulfill the obligation stipulated under such rules. And another one is enforcement. So any rule to be a law must be enforced by government. Students, as you may know, government has 3 main branches: the legislative part, executive, and judiciary. So especially judiciary must be able to interpret the rules as a binding so that it can be going to be law. Basic features of law. Law may have different features, but we can categorize basic features of the law: generality, normativity, and sanction. Let's see each of them briefly. Generality. Law is general rule of human conduct or behavior of action. What it means? In simple way, law is enacted for the whole society, that to be governed by such rules. It is not for a specific person. By no means law is specified as certain names. It is enacted for the whole subject that is governed by that particular law. So we can see these examples. If we take the presidential position, the President of the Federal Democratic Republic of Ethiopia is head of state. This is stipulated under Article 69 of the Federal Constitution. So we can see here, President is not the name of the person, but it is position. So it does not mention the name of the persons that come to the position. What the law do is that it simply specifies that any person that's appointed as president should become the head of the state. It does not mention the name of oligarchies or Sahale Orke. The second example is the Prime Minister shall be elected from among members of the House of the People Representatives. This is again stipulated under Article 73 of the Federal FDRE Constitution. So who is the Prime Minister? We don't know. It does not again mention the name of the person, such as Meles Zenawi or Haile Mariam or Dr. Abiy. This just illustrated for us that the law has general character. It is not specified for a particular person. Normativity features of the law. Law does not simply explain the human behaviors within the society, but the intention of the law or law is generally made just with the intention to create some norms in the society. That means to rule, to govern, to give some permission or to give direction or to prohibit certain action. It does not simply describe. Law creates norms, maybe giving permission, directive or prohibitive. So let's see these features in brief way. Permissive laws. Permissive means the law allows the subjects. When you are saying subjects, we mean that just any person that is governed by such laws. So it's up to the subjects, up to the persons to exercise or not to exercise such rights given to them. So such laws gives rights or option to the subject whether to exercise or not to exercise. Or if you are readers of laws, when you come across different laws, we can get provisions such as subjects has or have the rights to do such things. The subject is or subjects are permitted or allowed to do such things. Or the subject shall have the right not to do or the right to do something, because it gives to do or not to act. So this may be in negative connotation, this phrase may be in negative connotation, or it may be in affirmative connotations. So if you come across laws that are stipulated with such phrases are generally known as permissive behaviors or permissive normativity of the law. For example, accused person has the right to be informed with sufficient particulars of charge, broad against them, and to be given the charge in writing. That means that any accused persons have the right to be informed with the concerned government officials, such as police officer or by public officers. So when they are charged, they have the right to take such charges. When they approach court, they have the right to ask to just take the charge which is written in order to defend themselves. If they are not going to ask it, it is their right. It does not result in sanction. It's up to them to take or not to take. But if they are going to ask, they have the right to exercise that, but they can omit it. Another accused person has the right to be silent. When persons accused, especially when police officers examine such accused person, they ask a lot of questions in order to know whether such persons committed crime or not. In such cases, the accused person is not obliged in order to give any information for police officers or public prosecutors. Prohibitive. This discourages the subject from doing the act required not to be done. This again has negative provisions. It prohibits you. Such laws generally uses phrases like must not, shall not, and these phrases are very common, especially in criminal laws. So it prohibits. For example, any unmarried person who marries another he knows to be tied by the bond of an existing marriage is punishable with simple imprisonment. That means any unmarried person is allowed to marry another unmarried person. He is not allowed to marry a woman who is tied with another. That means the law simply prohibits polyandry. That's a woman shall not marry two or more husbands. The third feature of the law is sanction. Sanction means it is penalty or coercive measure that results from failure to comply with the law. As we've seen from normativity feature of the law, law prohibits or may order the subjects to do or not to do certain things. In such a case, any subject has obligation to obey such normative provisions. If it's going to fail, the law just penalize such subjects. By the way, sanction has very important purpose. The main purpose is just to prompt or to make ready any party or any citizen to respond. That means he's going to be ready. Okay? Guys, do you need to be prison? I hope you not. So, you will not going to commit crime because of such sanction. If there is no sanction, for example, if there is no penalty, you can do anything but you like. You can commit crime you like. But the presence of sanction or the behavior of sanction of the law just makes us ready to respond for such things. It makes us aware or it helps people not to commit wrongs and to obey with normative behaviors of the law. Such sanctions are commonly known in criminal cases. But there are also civil sanctions. Let's continue. Purpose and functions of the law. Okay, there are different purpose and functions that the law is going to achieve, but there are generally four major purpose and functions. The first one, establish standards, maintain order, resolve disputes, and protect liberties and rights. Let's see each of them in brief way. Establishing standards. The law generally establishes standard. When we say standards, law generally gives a guidepost for us. That means it gives certain standards based on which we are going to, or the subject going to evaluate whether his behavior is acceptable or not acceptable in society, criminal or not criminal, is it lawful or unlawful, legitimate or illegitimate. So the law just measures your behavior, that means your action that you take place within the society. An example is here, it's a crime to cause physical harm to another person without justification. Okay, so no one can cause physical injury on another person without any justified reasons. So, in general way, this provision stipulated for us, we cannot cause any physical harm on any person. For example, you are not allowed to throw a stone on another body and make him injured. You are not allowed to beat other persons and make him injured. Even your parents, your kids, any other. But there are situations that you can cause against such injury if you have justification. For example, in case of self-defense, so you can measure whether your behavior is legitimate or not based on such rule. You can get such standards in our law, especially in extra-contractual liability and also criminal law. The second purpose and function of the law is just maintaining order. Law maintains order. Because the law prohibits or because the law provides such normativity provisions in the law, it prohibits you not to do certain acts, or it may need you directly to do such things. In such manner, the law just intended to keep certain order within the society. For example, it enables police officers to caught and arrest just suspected person or commit crimes within the society. By doing so, the police officer just keep order within the society. If there is no law, especially normativity and sanction behavior as a law, we may not have even economic order. We may not have such good social order. People can do what they like within the society. So the law prohibits or the law obliges to keep certain order, prohibits bad behaviors within society, and enables to keep order within the society. The third one is resolving disputes. Resolving dispute means just solving any problems that's caused within the business or within any fields. If two businesses come to conflict, what they are going to do? So they have to have certain solutions that able to resolve such disputes or such conflicts between them. So the law generally establishes certain dispute resolution mechanisms. We can get formal and informal means of resolving disputes. The first one is formal means of disputes. The formal means of dispute in our country is court system. We can get courts at federal level and also regional level. And in particular session, we can get first instance courts, high courts, and also we can get Supreme Court, and even there are cassation courts. So any business person or business organizations that just got disputes can go to court and resolve their problems. There are another less formal ways or informal means of resolving disputes. These are what we call alternative dispute resolution, especially we call them ADR. This ADR may have different forms, but the main one includes, the first one is conciliation. Conciliation means two parties in conflict come together and they discuss their disagreements or they discuss on the issue or the matter on which they do not agree. They will not going to invite another third person, but they resolve their issues only between themselves. But the problem here is it is not binding. One party may not bind by the conciliation. If he is going to refuse or if he does not disagree with another person, he can go to another dispute resolution mechanisms. And the second ADR is mediation. As its name indicates, mediation means just solving problems by inviting the third person. So in this case, the party to the dispute invite another third person by their agreement, the person who they choose, and then they produce the evidences, the facts for such third persons, and such third person considers and gives suggestion. The third person is not going to give here decision. The third person rather gives only suggestion. Also, here another problem related to mediation is the suggestion given by such a person is not binding. Any party who disagree or who is not agreed with, or any party who complains with such suggestion can refuse and just go to another dispute resolve mechanisms. The third one is arbitration. Generally in business, arbitrators are organizations or institutions that are specially licensed. For example, Chamber of Commerce. When business organizations come to conflict, they can go to arbitrator or to Chamber of Commerce and produces their facts and evidences, and the arbitrator going to give decision. This is different from the two ADRs, because here the arbitrator just acts as judge in the courtroom. He considers cases based on the normal or regular laws and also maybe contracts. Then it gives decision. It does not give suggestion like conciliation and mediation. So the decision that is given by this arbitrator is again binding. There is similarity between the court systems and arbitration system. This means in both cases, the decision passed is binding one. Okay, the fourth purpose and function of the law is, which is we know in common, protecting the liberties and rights of citizens. Guys, you know this one from your CV course from grade 5 till 12. So, especially such rights and liberties as proclaimed under the Constitution. So, the Constitution just stipulated such liberties and rights so that it is protecting such rights. For example, we can get these issues from Article 15, Article 60, and Article 70. Please go to refer and see such your rights and your liberties that is stipulated under the FDRE constitutions. This is a very common one. Meaning of business law. This is the last chapter objective of this course. So, and also this is very important for our later lessons because the course is generally talking about business law. So, business law generally encompasses or includes all of the laws that direct how to run and how to form business. So, business law governs the procedure of formation of the business and also the operating process of the business. That is, business law establish the rules that all business should follow while during its formation phase and also during its operation phase. Business law generally includes many laws. That means it gets its source from different sources. Contracts, negotiable instruments. That means business law gets its source from all these. These laws are scattered. You can get contract in civil court, negotiable instruments in commercial court, agency, especially in civil court, employment both in civil court and business organization, mainly stipulated under commercial court, properties in civil court and also commercial court. This means that it emanates from different laws. There is no a simple codified documents that we call business law in our country. From such definition, we can just say something about the nature of business law. Business law is just scattered. That means it gets its sources from different areas. Law of contract, law of employment, law of insurance, the constitution, bailments, agencies, sales laws, etc. So it is scattered. That means there is no a simple codified business law document in our legal system. Business law governs a wide area. Business law generally governs what we call business activities, especially stipulated under Article 5 of Commercial Code of Ethiopia. So there are activities that are mentioned in business. We can learn this one in chapter 3. Another feature of business law is a civil law. A civil law, and also it is private law. We are talking about the business law within Ethiopia. We are not talking about the whole general. Okay, sources of business law. What are the major sources of business law? Business law can get its source from Constitution, Ethiopian Commercial Code, licensing and registration proclamations and regulation proclaimed under issue federal levels, and also there are regional levels, Ethiopian Civil Code, and also the labor law. That means business law gets its source from different areas. That means business law is scattered one. Okay, thank you guys for just attending this video. This video is just aimed to help you understand your main material. So I may open my own channels on YouTube, and you may subscribe and get different shorts, quizzes, and also different questions. You may be required simply for subscription. So thank you. Bye. Till we meet in our next video.